Unions are relieved as the Supreme Court leaves the right to strike intact. Oh, look at that manufactured consent right there. Oh, unions are relieved by this case. Oh, yeah. Unions are grateful to the federal government. Thank you. Thank you, federal government. Thank you, Supreme Court. So what happened here, right? Okay. So basically, a while ago, there was a strike. Some concrete truck drivers went on strike. What's the name of the company they striked from? It's called Glacier Northwest. There we go. Uh, Now, a bunch of workers, they went on strike, and if you know anything about a concrete mixing truck, all right, they spin because concrete is constantly undergoing a chemical reaction. When they spin the big cylinder in the back of a concrete truck, what they're doing is they're trying to use agitation to delay the chemical reaction that causes concrete to harden. So normally, concrete trucks are loaded up, chemically mixed, agitated, and gotten ready before the truck sets out. The truck starts to spin to delay it from hardening, and then it needs to get there in time so it can be poured into the mold. You know, this happens all over the world all the time. It's a very normal, very standard process. And the drivers for some of these concrete trucks went on strike after arriving at location. Now, they left the truck spinning, and as I understand it, the trucks did not get damaged by their decision to walk off and strike right then. However, the concrete was ruined. Past a point, the concrete has set enough in its chemical reaction that it cannot be used anymore. It's no longer viscous enough. It can't be poured properly. So the concrete gets ruined past a point. So money was lost, you know? That concrete can't be used again. The company took an L, and the company was so mad that they had to take an L, they filed a lawsuit against the International Brotherhood of Teamsters, the union we're talking about here. After the union's contract had expired, negotiations broke down. The union signaled its members to walk off the job after its drivers had loaded that day's wet concrete into Glacier's delivery trucks. The company sued the union in state court, claiming the truck drivers had endangered company equipment. Wet concrete, it explained, hardens easily, and the company had to initiate emergency maneuvers to offload the concrete before it destroyed the trucks. Now, right away, okay? Right away. The spinning is to keep the concrete from separating. Sorry. All right, well, thank you for the technical correction. I don't think it changes the fundamentals, but yes, concrete mixing, very important structural engineering job, okay? All right, okay. Not a structural engineer. The basics. We're getting the basics, okay? So here's the thing, okay? As we all know, all right? As we all know, strikes always, definitionally, cost companies money. That is literally the point. Like, that is literally the point. If they didn't, then it wouldn't, that wouldn't be a thing. That's what they're supposed to do. The accusation from the company was that it wasn't just the lost revenue from the non-participation of the workers who were striking. It was the fact that actions had been taken to both damage resources and put the trucks at risk. That is what they're suing over. So there is a legal distinction here, which I think is maybe a little arbitrary, between money lost due to damaged or destroyed goods and money lost due to the lost revenue of the workers' non-participation. If you get down to the brass tacks of it all, money lost is money lost, right? I mean, you can imagine if a company loses $100,000 in what otherwise would have been filled contracts because their workers are striking, and they lose $100,000 because, like, the consequences of the concrete being left to dry and trucks getting damaged, they're both $100,000. But there is a legal difference, one that I think is maybe a little bit vague and tenuous, but there is a legal difference. And they sued over the damage. Now, this is unusual, okay? And the reason it's unusual is because normally when there are disputes that arise as a product of unions and strikes and contract labor and blah, blah, what do? What happens when that happens? Well, the Washington Supreme Court, that's the one that I'm under, thank you, ruled that Glacier's complaint should have been filed with the National Labor Relations Board. The NLRB is responsible for, theoretically, protecting the right for workers to strike, for managing disputes between workers and companies. This is their thing. So essentially, the state court said after the company sued, hold on, this is the NLRB's job. This isn't our job. You don't take this to the courts. Like, if you have a problem with conduct involving a strike, you go to the NLRB. Otherwise, like, what are we here for, right? The company appealed the decision, and it made its way up to the Supreme Court. And you'll never guess what the Supreme Court decided on. In an 8-1 decision, the Supreme Court found that the union is civilly liable to be sued for the damages associated with the concrete and the trucks and the blah, blah, blah. Now, I saw some liberals getting in a fuss over this on Twitter. They were saying it's justified. I want to talk about this for a second, okay? Because this is really, really important, all right? This is where we're going to have to get cerebral. Follow through with me here on this. Now, my opinion on this subject is actually exactly the same as the one dissenting Supreme Court Justice, Ketanji Brown Jackson, who, since we agree on this, I guess we're just as smart and legally educated. I'll deliver the argument, if you will. The reason why the NLRB, the National Labor Relations Board, the reason why they tend to handle this stuff is because the disputes between companies and workers usually get really complicated. It's like this ongoing process of negotiating contract labor and strikes and union deals and this, that, the other. Labor relations, managing this kind of stuff. This isn't like a court decision. Think about what a court does. A court, the Supreme Court, the Washington State Court, their job is to make rulings on specific issues that are used as precedent for future cases. That's literally how precedent works as a concept. When the Supreme Court makes a ruling, that gives like info to all the courts underneath it, which is all courts in the United States, of course. It's the Supreme Court, on how to rule in the future. It's, jurisprudence. And the problem here is that there's actually a really big difference between the NLRB and the Supreme Court finding the striking workers civilly liable. If the NLRB does it, what that means is that in this specific instance, the company can sue the union for the damages associated with the time of their strike. Now, do I agree with that decision? The honest answer is that I don't actually know. I do know for a fact that the point of striking is to cost companies money, but there are limits to that. I don't think, for example, that if you're striking workers should then be allowed to, like, destroy company property. Like, obviously, that's not, like, I don't think you should be able to, like, play around with this. Like, I don't think a worker should go, like, I'm striking, like, throws a rock through a window, and, clearly there should be some kind of limitation on this, and the NLRB's job is to rule on this. The NLRB's ruling, even if it was identical to the Supreme Court ruling, would have been narrowly applied. But what's happened now that the Supreme Court of the United States has ruled that striking workers and the unions that organize them are civilly liable for damages, negligent, or risky behavior associated with striking? You understand? This is really dangerous. This is a huge blow against workers' rights. Look, it is incredibly damaging. Please look at this, all right? At the same time, the court's majority decided the case in favor of the company in a very fact-specific way. The court ultimately said the union's conduct in this particular case posed a serious and foreseeable risk of harm to Glacier's trucks, and because of this intentional harm, the case should, and this is the critical part, not have been dismissed by the state Supreme Court. The ruling from the Supreme Court is explicitly saying that in the future, cases like this should be decided by courts, which would be affected by the precedent of the Supreme Court ruling and not by the NLRB. They are explicitly stating that in instances where corporations feel as though there is a serious and foreseeable risk of harm to their corporate property, that their complaint, their contest, should go to the courts rather than the NLRB. Do you understand the difference here? Do you understand why this is so damaging? Why this went through the courts rather than it going through the NLRB? The point of this is now the courts have additional power. Not only power, but they're being told, corporations are being told, bring this shit to the courts, okay? Hey, man, what this means is that, keep in mind, lawsuits cost money to fight, even if they're bullshit. This means that more corporations are going to file lawsuits against unions that lead workers to strike against them, whether or not there's any actual, like, serious and foreseeable risk of harm to corporate property. That still potentially is years of civil litigation, of paying for lawyers to fight that off, rather than going through the NLRB, which would have been able to deal with the situation, as bad as the organization is, without getting you stuck in the legal system. Like, this is insane. And think about it, too. Serious and foreseeable risk of harm to corporate property. Where are the limits to that, right? What if food workers or grocery workers strike? Like, that product expires. What about delivery workers? Deliveries expire. There are myriad industries in which it would be virtually impossible for workers to strike without posing some kind of serious and foreseeable risk of harm to corporate property, depending on where you draw the line at corporate property. The NLRB could have handled stuff like this. And again, keep in mind, the NLRB is not some kind of radical socialist organization. This isn't some, like, crazy left, like, the NLRB does not, obviously they don't protect unions, because unions in this country are dead. And they will be more dead after this. But this was a deliberate move. And what's more, it was an 8-1 decision. Not a 6-3, not conservatives versus liberals. It was an 8-1 decision with only one single sane voice of reason in the Supreme Court to act against it. Excuse me. Insane. I could be wrong, but I think Kagan and Sotomayor may have gone with the majority ruling to avoid Alito's concurring ruling being the majority. It was 5-3-1. That would have explicitly killed NLRB jurisdiction rather than weaken it. Oh, you think they moved over just to keep the worst iteration of the majority opinion from going through? Hold on. If that's the case, that would be like lesser evilism. We'll see. Alito, Gorsuch, and Clarence Thomas, the three most conservative justices, wrote separately to express frustrations the court did not go further and reverse a lot of the protections for workers' rights. Alito virtually invited Glacier or other business interests to come back and try again. Nice. Whereas the majority, Amy Coney Barrett, John Roberts, Kavanaugh, Sotomayor, and Kagan. Okay, so if that's the case, then I actually agree. Wait, hold on. Selenium, I think what you said is correct. I think the reason the liberal justices voted the way they did was so that the majority opinion wasn't as bad as it could have otherwise been. Because otherwise it might have been a 3-3-3 split, and they might have sided over with Alito, Gorsuch, and Clarence Thomas. Well, what a fun system that we live within. That's super good. Bosch, the scope of the case would not cover goods that expire, at least not yet. That is already case law, and this did not overturn that. It means they have to take extra care to protect equipment, not products. Yeah, but you understand how, like, vague and tenuous that is, right? The main thing that concerns me is the fact that corporations are being explicitly told to go through the court system now, rather than, because now this means that if corporations have workers strike and they're angry and they want to get something from it, they want to recoup some of their losses, they now have a legal pathway to bringing this to the courts and threatening them with years of litigation, expensive litigation to manage, because the Supreme Court precedent is literally saying this should not have been dismissed by the state Supreme Court. And what is a corporation going to determine as a serious and foreseeable risk of harm? In this case, if we're only talking about damage to equipment, the truck survived. So apparently the only thing you need now to establish this this legal channel of attack is just the risk. That's it. So we're not even talking about the cost of the concrete. We're talking about a corporation's perception of the perceived risk of harm to their property, to their equipment. And if they think they have that, then they go straight to the courts, and the courts now know that the Supreme Court is saying that they should take it seriously and not kick it to the NLRB. Again, not a legal expert. It's pretty bad. And what I'm saying here is in concurrence with the dissent from Justice Jackson. So I'm not like, this isn't some like wacky, like leftist socialist perspective or anything. I am agreeing with her perspective on this, with the summary of the dissent that I have read from her. It is terrible. It is disgusting. It's like, it's very bad. It's not good. It's not good. Not good. Do we just die? Well, eventually we do, yeah, but hopefully we get lots of time before then, you know. If the labor board had ruled the conduct wasn't covered by the NLRA, it would have been kicked to the courts and we'd have been here anyway. Yeah, but don't you think there's a pretty huge difference between go to the NLRB first, and then if it doesn't apply, go to the courts, and go to the courts, which are being told to take your case, by the way, and, you know, maybe then they try to kick you to the NLRB. The channel of, like, it's just, this opens up so much abuse of power for corporations. So much abuse of power. What can we do to fix this? Literally nothing. It's the Supreme Court. The Supreme Court is just a collection of, like, high priests that get to just decide things. Yeah, the Grand Wizards. What happened to Biden adding justices? Biden has never seriously talked about adding justices. You should bring a lawyer on stream to discuss this. I think this is a bit out of your wheelhouse. Well, I'm not a legal expert, but again, I am just citing the perspective of Justice Jackson. I mean, if you want, we can read that. Here, Supreme Court strike ruling, Jackson dissent. Liberal Justice Jackson has issued her first solo dissent in a Supreme Court merits case Thursday. Jackson wrote that the courts had no business delving into this particular labor dispute at this time. The majority also misapplies the board's cases in a manner that threatens to impede both the board's uniform development of labor law and erode the right to strike. Yeah, I completely agree. Her primary argument is essentially that, like, this is an effort by the court to both make things easier for corporations to sue striking workers and also direct legal concerns to the courts rather than having the NLRB look over it first. The filing of the General Counsel's administrative complaint necessarily suffices to establish the union strike conduct is, quote, arguably protected within the meaning of Garmon. Thus, the General Counsel's complaint should have been marked the end of any court involvement in this matter, Jackson wrote. So I agree with her.